for the sale of the property purporting to be a sale deed is executed by the owner, and he writes the same on first of the month, but gets it registered on the 15th of month. The registration takes place on the 15th of the month. The document was executed on the 1st of month. The requirement of section 54 is fulfilled on the 15th. The question is whether the transfer of ownership took place on 1st or on 15th. The registration says that the transaction is completed on 1st. Although the registration is a requirement, and without registration there cannot be transfer, and the title of the vendor does not pass on to the vendee without registration of the document. But the declaration in the document on the 1st of the month is operative, and the man becomes owner on 1st, in spite of the fact that it was registered on 15th. So, when the document is not registered, the transfer does not take place. The sale is not complete. The title of the vendor does not pass on to the vendee. But when this document is registered, it shall be operative on the date when he declared that he made the sale. This mode of transfer of property under section 54 is applicable only in the urban area of Punjab. But what about the rural areas where section 54 does not apply? A man is living in a village out of the municipal limit. He wants to dispose of his property by way of sale. He enters into a sale agreement, then transfer the same to the other person. Registration is not a requirement. Then how the title shall be transferred? The law is very much clear on the subject, that oral sale is as valid as the sale effected through a registered instrument. Oral sale is permissible, but as we have studied that there are 4 elements of sale, so far as these 4 elements are concerned, they remain in the field. Even the property is rural. There should be parties, there should be subject matter, there should be transfer of the property, and there should be price. But it adds 2 further things. 2 things are added therein. Number 1, not promise of the price, not part payment of the price, but the whole of the price should be paid. Number 2, possession should be delivered. Delivery of possession and payment of price are necessary to constitute a valid sale in the areas where section 54 is inapplicable. So we have seen that there are 2 modes of transfer of ownership through sale. Number 1 is the section 54, which requires the registration of the document, and number 2 is the oral sale. Oral sale is as good as the sale in writing. Oral sale transfer the title. Oral sale transfer the ownership. If the sale is absolute, the title of the vendor passes on to the vendee on the delivery of possession. In this situation, this question arises. In this situation, a question arises as to if two persons sit in a room, one pays the amount and other plows the field, he got the possession, he got the money, the sale is complete. How to determine it? For the purpose of determination of oral sale, the best methodology which has been provided by the law is Section 42 of the Land Revenue Act, where a person transfers his ownership through an oral sale and receives the price, the transfer of ownership is complete and the sale is complete in all respects, he shall report the matter to Patwari, who shall record the mutation and then a report in his Roznamcha. Thereafter, the sale shall be sanctioned by the competent revenue authority. So that mutation is a piece of evidence for the purpose of deciding that the sale was complete. But do remember one thing, that this transaction is something different and mutation is something different. Mutation is a piece of evidence when the transaction takes place prior to the mutation. So whenever you give a document before any authority, it shall be used as a piece of evidence. It is a piece of evidence and not the transaction itself. This is the reason why the law says that mutation does not create any right. Mutation does not create any right, but it is a good piece of evidence regarding the transaction of sale, that the sale was completed prior to it. So up to this time, we have studied two aspects: complete sale under urban areas and complete sale under rural areas. The mode of both is different from one and other. These are different things. But when the property is municipal limit, then of course the transaction must be effected through registered instrument. But when there is a rural one, you can adopt any one of the two. The registration may be made, you may get the document executed and registered for the completion of transfer of ownership and for the completion of sale, and you may take resort to the oral transaction. So the second part is agreement to sell. That part shall be studied in the next meeting, and thereafter we shall also study the distinction between the sale and agreement to sell. This agreement to sell is usually known as contract for the sale of immovable property. So contract for sale of immovable property is the subject for the next meeting, and thereafter we shall draw a distinction between sale and contract for sale. Thank you very much.